Hi everyone. And amongst us we have Justice V. Ram Kumar, a former judge from Kerala High Court, and his passion to take the knowledge to the next level and make it understand for everyone is now, I think, a common name in everyone's house, especially in the legal fraternity or those who have been connected one way or the other. And therefore, even though we can't say as such, but slightly despite the fact of the health challenges, he has acceded to our request to take these sessions. And therefore, we have also started short talks on short topics. And today is on dispensation of personal attendance before the magistrate. And for the students of law, they can understand the nuances more, or it will touch around section 205 of the CrPC. I will ask sir to take the questions himself and then answer himself.
Thank you. Thank you, Mr. Vikas. Good evening, friends. See, there may be genuine reasons and genuine situations when an accused person is unable to personally appear before court. It can be his inability to make his first appearance before the magistrate. See, once an accused receives process or warrant, once he receives summons from a magistrate court, he has to appear before the magistrate. So it may be is a situation of first appearance before the magistrate, or it may be his subsequent appearance during the trial of the case. Now, before the trial, the plea of the accused has to be taken, charge has to be framed, plea of the accused has to be taken. Does he have to personally appear before the court invariably in each and every case? Then we have seen while discussing bail, the rule is bail and jail is an exception. Therefore, what is supermost or what is uppermost in the mind of a criminal court while granting bail is to ensure whether this person who is an accused will appear before the court during the trial of the case. His availability for trial is the uppermost question. Therefore, once that is ensured, a criminal court need not be vindictive towards the accused, who is, mind you, insulated by the presumption of innocence until proved guilty after trial by a competent court. Therefore, with this understanding of the position, let us try to answer a couple of questions, which are the usual questions asked before a court of law. Now, first question is, accused is working abroad and against whom non-bailable warrants of arrest are pending. He has come back to his native place in India and has filed through an advocate a petition for permanent exemption from appearance under section 205 CrPC. The question is, can the magistrate grant it even in the absence of the appearance of the accused, even with the absence of the accused before the magistrate? Can the magistrate grant the application? The answer is yes. The mere pendency of non-bailable warrants cannot be a ground to refuse an application under section 205 CrPC for permanent exemption from appearance. You may refer to Sarath S versus State of Kerala, 2017 volume 3 KHC 383 by Justice Sunil Thomas, who must be familiar to you. He has given so many webinars to Beyond Law CLC. His verdict, Sarath S versus State of Kerala, 2017 3 KHC 383. So just because warrants are pending against him, he need not be worried. He can file an application through his counsel for permanent exemption under section 205. And if the court is satisfied, court can grant permanent exemption even without seeing the accused before him. Now we pass on to question number 2. Can the accused make his first appearance through his counsel before a criminal court? First appearance, even the first appearance. Yes, that is what the Kerala High Court again said in Reddy versus Messrs. Excel Glasses Ltd. 2010 Kerala High Court cases 542 by Justice P.S. Gopinathan. P.S. Gopinathan of the Kerala High Court has taken the view that even for the first appearance, the accused can enter appearance through his counsel. he need not be physically present before court. But it all depends on the facts and circumstances of the case. Supposing there are some previous convictions to his credit, then court may not allow the counsel to represent him. Court may require that let him come before me. Otherwise, the court need not be so vindictive towards the accused just because he is an accused. Because mind you, he is insulated by the presumption of innocence until proved guilty after trial. We pass on to next question. When the accused has been granted permanent exemption under section 205 CrPC, can the magistrate record his plea, the plea? That is when while framing charge, after framing charge, the court has to record his plea. Can that plea be recorded through the advocate? While framing charge, after framing charge, the court will have to take the plea. What do you say? Do you plead guilty or not guilty? Even that can be asked. The accused need not be physically present. It can be pleaded through the counsel. The answer is yes. He can plead guilty or not guilty through his counsel. Beautiful decision by Justice K.T. Thomas in Bhaskar Industries Limited versus Bhiwani Denim and Apparels. Bhiwani Denim and Apparels. AIR 2001 Supreme Court 3625. Justice K.T. Thomas. His Lordship held that even the plea of the accused can be recorded through his counsel. Counsel can, on instructions, counsel can say whether he pleads guilty or not guilty. Even the physical appearance of the accused is not necessary. Then we pass on to the next question. Are there any requirements to be complied with by the accused seeking permanent exemption under section 205 CrPC during the trial of the case? Now we have crossed to the stage of framing charge. For framing charge, he has pleaded guilty through his counsel. Now the question of trial comes. Now he is to face trial. Then whether he can apply for permanent exemption. He can apply. Under section 205 CrPC, he can apply for permanent exemption. But are there any conditions? CrPC doesn't lay down any condition. The judge made law. Again by Justice K.T. Thomas, the great judge. Barring a few exceptions, the accused has a right to be present when evidence is taken against him in view of section 273 CrPC. Section 273 CrPC mandates that evidence has to be recorded in the presence of the accused. There are a few exceptions. For example, if he is unnecessarily dislocating the trial, there are some troubleshooters. They may dislocate the trial, and their presence may be ill-advised. In such cases, his personal exemption can be, his personal appearance can be dispensed. Otherwise, he has got a right, statutory right, which also flows from Article 21 of the Constitution of India, fair trial. So the evidence has to be recorded in the presence of the accused. Now, when the accused wants the trial to be conducted in his absence, he has to file a petition and an affidavit incorporating three important aspects. One, the evidence, he may request the court that the evidence may be recorded in my absence. He is giving the permission. He is forfeiting his right under section 273 CrPC. 273, he has a right to be present when evidence is recorded. He is forfeiting that right by requesting the court, my evidence may be recorded in my absence. Second condition, his counsel may be permitted to represent him during his absence. The second condition has to be, which he has to incorporate in his affidavit is, during my absence, my counsel may be permitted to represent me. Third is, since his evidence is going to be recorded in his absence, he will not raise any question of identity. He will have to say that, please, evidence may be recorded in my absence. Number two, my counsel may be permitted to represent me during my absence. Number three, I will not raise any question of identity. These are the three conditions which he has to incorporate in his application for permanent exemption under section 205 CrPC. UP Pollution Control Board versus Mohan Meekins Limited, AIR 2000 Supreme Court 1456, AIR 2000 Supreme Court, 1456, Justice K.T. Thomas. Again, there is yet another decision by Justice K.T. Thomas, which I have already given you. Bhaskar Industries Limited versus Bhiwani Denim and Apparels Ltd AIR 2001 Supreme Court, 3625. Now you see, when the accused is not in the dock during the trial, the prosecution witnesses will not be able to point out the accused and say he is the person who committed the offense. He is the person who attacked me. They will not be able to say because accused is absent. So the having chosen to remain absent, the accused cannot during trial, after trial, turn around and say that none of the prosecution witnesses has identified me. He cannot say. He cannot be heard to say because he has filed a petition praying for his exemption and permitting his counsel to represent him, and that he will not raise any question of identity. This is that question. Once he files such a petition, he cannot turn around and say, none of the prosecution witnesses has identified me. I was not in the dock. He cannot say because he has voluntarily forfeited that right. Therefore, he cannot thereafter say that no prosecution witnesses identified me. No, therefore, that is why this third condition is also insisted by the court. Therefore, once he incorporates these conditions in the application for permanent exemption, the court can grant him permanent exemption. Of course, there can be other conditions also that he will not leave the country without informing the prosecution, without informing the court. He shall not place himself beyond the reach of his surety. All those additional conditions can be imposed by the court. But if he is granted permanent exemption, for granting this permanent exemption, he will have to incorporate these three conditions. That is what the Supreme Court said. With this, we conclude today's topic. Thank you.
Thank you. Thank you, sir.